This Honorable Court of Appeals of Tennessee is now in session.
Good morning and welcome to the morning session of the Court of Appeals. Your panel this morning will be Judge Armstrong from Memphis, Judge McGee from Savannah, and I'm Judge Golden from Memphis. We'll be hearing this matter just as if we were hearing it in the courtroom. The appellant can reserve up to 5 minutes for rebuttal, and I may have already done that with Mr. Hibner. Anything we need to address?
No, Your Honor.
All right, you call the case.
Stephen Jeffrey Archer versus Sodexo Operations, LLC et al.
We'll hear from the appellant.
Thank you, and good morning to members of the court and to Mr. Walk. My name is Jordan Watson, and I represent Sodexo Operations, LLC and Sodexo, Inc. in this matter. Thank you to the court for allowing me to present our positions today. This matter involves a claim of wrongful death arising out of an alleged incident that occurred at St. Francis Hospital in Memphis. According to the complaint, the decedent was improperly served a breakfast tray while a patient at St. Francis aspirated and sometime later passed away. At the time of the alleged incident, the appellant, Sodexo Operations, was a party to a contract with the owner of the hospital to provide food preparation services. The lawsuit was filed pursuant to Tennessee's Healthcare Liability Act, thus implicating the various procedural and notice requirements of the act. On behalf of Sodexo Operations, we filed a motion to dismiss in the Circuit Court of Shelby County, arguing that this lawsuit was not filed within the applicable statute of limitations due to the plaintiff's failure to comply with the notice requirements of the Healthcare Liability Act. The trial court denied the motion but granted our Rule 9 motion. This court also granted the Rule 9 application, resulting in this appeal. So this appeal concerns whether the plaintiff complied with the notice requirements of the act and whether the plaintiff was entitled to the 120-day extension of the statute of limitations provided by Tennessee Code Section 2926-121. So given the statute of limitations arguments, the timeline is going to be very important to this case. The incident giving rise to this action occurred on August 26, 2018. On June 26, 2019, 10 months after the incident, statutory notice under the act was issued to the hospital, St. Francis. The very next day, St. Francis responded that Sodexo may be a proper party. On August 19th, 2019, just before the one-year anniversary of the incident, notice was issued to Sodexo, Inc. Pursuant to the act, Sodexo, Inc. responded within 30 days and identified Sodexo Operations.
Excuse me, was this the time frame for this case? Was this during subsequent to the time that statute was passed that required if a party was aware of another party that could potentially be liable, that they had to identify that party?
Yes, it was.
Was that statute in effect?
Yes.
And so how does that play into the fact that St. Francis said Sodexo may be? I mean, did they have an obligation to say, I mean, they knew who they had a contract with. Did they have an obligation to identify your client, for instance, versus Sodexo, Inc. if there's a chance that could have been a mistake or not accurate or something like that? It seems to me that they have an obligation to file something in writing as to who this party might be. Is that correct?
That is correct. And I believe Mr. Walk and his client in their brief included the email that the hospital sent back. And basically it identified Sodexo as a potential party to the lawsuit.
Well, what effect does that have that they didn't identify the correct party?
Well, I think what this really boils down to is that the plaintiff was aware that there was a cause of action on August 26th of 2018 and had a duty to start investigating that cause of action. 10 months then passed by before they issued the notice to St. Francis, and then eventually Sodexo Operations was identified within the next few months.
All right, go ahead.
Okay.
Mr. Watson, before
yes.
you continue, let me ask you something. Is there anything in the record that we have before us here to suggest that plaintiff should have reasonably discovered the true identity of Sodexo, or that Sodexo was even involved during the period between the injury, which I believe was August of 2018, and that email, which first occurred raising the name Sodexo? Is there
Well-
anything that would suggest, anything in the record that would suggest that?
No, ma'am, there's no documentary evidence of that. What I would say to that, though, is obviously the plaintiffs were aware that a claim existed against another party, and at that point had the duty to start investigating their claim, which under the Healthcare Liability Act would include issuing notices to the known parties. And then under the Act, there are procedures in place that ensure that plaintiffs are made aware of other parties. If they're not made aware of other parties, for instance, if a potential defendant did not respond, the Act protects plaintiffs in that situation. And also, the Act incorporates, of course, the comparative fault statute and allows plaintiffs to add defendants in through the comparative fault statute.
Thank you.
Okay, so obviously, as the court is aware, this appeal deals heavily with Tennessee's discovery rule. In other words, does the discovery rule set forth in the Healthcare Liability Act apply to this matter? And if so, does it impact the notice requirements as to Sodexo operations? The Healthcare Liability Act's discovery rule was found at section 2926.116. When the General Assembly adopted the Healthcare Liability Act, they expressly adopted a statutory discovery rule. Section 116 sets out the 1-year statute of limitations for healthcare liability actions and provides that in the event the alleged injury is not discovered within such 1-year period, the period of limitation shall be 1 year from the date of such discovery. The General Assembly was free to use whatever language they pleased when adopting the discovery rule, including using the term accrued or even setting out specific elements for application of the rule. Instead, they chose the clear and unambiguous language found in this statute. And as a result, the language should be given its full effect pursuant to law governing statutory interpretation in Tennessee. So to understand why the discovery rule was adopted by the General Assembly, we must look at the first Tennessee case adopting the rule, and that, of course, was Teeters v. Curry. In Teeters, the plaintiff underwent a tubal ligation on June 6, 1970. However, she discovered she was pregnant on December 6, 1972, or approximately 2.5 years following the procedure. Obviously, without the discovery rule, it would have been impossible for the plaintiff in that case to bring suit within the 1-year statute of limitations. Stated differently, the statute would have run before the plaintiff had any knowledge whatsoever that she had even suffered an injury. The Teeters decision was incited in a non-healthcare case in McCroskey v. Bryant Air Conditioning. That case involved a defective gas furnace. The court analyzed whether the statute began to run on the date of sale or the date of injury. If the date of sale was used, the plaintiffs, like Teeters, would have been required to bring suit before an injury occurred. So these types of factual situations are why the discovery rule was adopted and why the General Assembly employed the language that is used in Section 116. Those facts seen in Teeters and McCroskey are obviously not present in this case. This is not a latent injury case where the injury could not have been discovered during the 1-year period following the alleged negligence. The alleged injury to the decedent did not go undetected. Instead, the alleged injury in this case was discovered on August 26, 2018. And as a result, under that plain language of Section 116, the discovery rule passed by the General Assembly is simply just not applicable to this case. But even if the discovery rule is considered, the plaintiff's claims are nonetheless untimely. The Supreme Court has stated that the pertinent question is whether a plaintiff is aware of facts sufficient to place a reasonable person on notice that the injury was the result of the wrongful conduct of another. That's the test. The plaintiff doesn't have to know every detail of their claim. When they are placed on notice that a tort has occurred or that they have been injured as a result of another, then the claim accrues.
Regardless of whether they know the party, Mr. Watson?
Well, if they know that they have been injured as a result of the alleged negligence of another person, then the claim accrues and the duty to start investigating promptly is placed on the plaintiff. The plaintiff cannot wait for 10 months to start investigating their claim and then try to depend on the discovery rule on the back end. So we've cited Kerry v. Bourne in our brief, and just briefly, Kerry involved facts similar to this, where the plaintiff alleged that while he knew he had been injured, he hadn't been able to conduct an investigation to determine who the correct defendants were. The appellate court rejected those arguments, and respectfully, it's our position that this court should reject those arguments as well. So I see my time is running down. So obviously, we're asking the court, based on these arguments and what's contained in our brief, to reverse the trial court's denial of my client's motion to dismiss Sodexo operations from the underlying case. Thank you.
All right, thank you, Mr. Watson. You'll have your rebuttal.
Thank you.
We'll hear from the appellee.
Thank you, Your Honor. May it please the court, good morning. My name is Bill Walk from Shelby County, and I represent Stephen Archer and the heirs of his family. And I appreciate y'all hearing our case today. And first of all, I'll just say in response to listening to Mr. Watson's argument, I think that the court's questions were very pointed and very accurate. This is a discovery rule case. And what he stated in the standard of the law was that he has to know that their injury had occurred. The discovery rule requires that. But as Judge Armstrong pointed out, you also have to know the source of the injury. And in this case, there was absolutely no reasonable way whatsoever to understand what the source of the injury was until at earliest June 27th, 2019, and more likely not until September 19th, 2019. And just to kind of go through the facts, as Judge McGee pointed out, the injury happened August 26, 2018. Between August of 2018 and June of 2019, there's absolutely no documentary evidence whatsoever that would give anyone notice that Sodexo Operations, Inc. provided food care or any other services to this plaintiff. The plaintiff was there for a peg tube. He wasn't even supposed to be getting food. Nowhere in the medical record, nowhere in any records is there anywhere available that says Sodexo Operations, Inc. or LLP. More importantly, so we've got the email, and I think that's important. So notice letters were sent on June 26, 2019. The day after, counsel for St. Francis, Karen Copeland, wrote back and said, I don't know much about this one, but from what little I know, this may be an issue with the dietary people. Dietary is contracted out to Sodexo. So as a result of that, our office spent a lot of time and a lot of effort. There's an affidavit of Kelly Hagee listed in there that said 300 internet pages, went through the Secretary of State, went through the website of St. Francis, everywhere she could, and found out that the only thing she could find was Sodexo Sodexo Inc. Sodexo Inc., of course, has the same counsel, same process, same agent for service of process, same address. And so we were then on the crux of a dilemma because, and then it was not till after the statute, after the 26th on September 19th, when actually Sodexo Inc. wrote the letter to us and said Sodexo Operations. So we were on the horns of a dilemma at that point. Obviously, more than 1 year had passed since the injury. And so for the first time, we hear about Sodexo Operations. I don't believe that those letters had the ability to trigger the comparative fault 90-day window because there was no certificate of good faith. If you saw that email, it was just, I think they may be involved. So we didn't believe that would trigger. So our choices were to go ahead and amend our letters, which we did, and not sleep on our rights the next day, or to wait and hope that St. Francis issued a comparative fault defense, which would then trigger 90 days. And so we decided to act immediately because we didn't have any reason to know. And the best evidence of this is in the hearing in front of Judge Russell a year later. This is in 2020. This is the lawyer for St. Francis Hospital who had the contract with the dietary services, end up being Sodexo Operations. But here is counsel for St. Francis, and I quote, when we received this initial notice of intent letter, we were aware that Sodexo provided the dietary services. However, we had not yet obtained a copy of the agreement between the hospital and Sodexo to understand the full corporate name of who contracted to provide that service. And in fact, as Mr. Watson can attest, I still don't have the full copy. but I have an amendment that I obtained to that agreement after the lawsuit was filed. And then Judge Russell responded, what you're saying under the circumstance, in all honesty, you did not know or have any reason to know about any distinction vis-a-vis Sodexo Inc. and Sodexo operations. Is that what I'm hearing? Ms. Copeland, that is correct, Your Honor. And then, of course, Judge Russell said in his ruling, we don't really know how two different entities fit into the overall picture at St. Francis Hospital. And the more I've listened to the arguments that are made and everything that I've seen and read, I am compelled to a conclusion that given the uncertainty of the entire picture, the motion should be denied. And the basic argument is this: if the entity that actually had the contract with Sodexo doesn't know who the proper entity, how can the courts put the burden on a plaintiff who has no idea who the correct entity? We don't have access to their contracts. We don't have access to their documents pre-suit. So we had no reason whatsoever under any standard to know that Sodexo operations provided food services to our client back in August of 2019. And so in our case, we've cited several cases. One of them was the discovery rule case, of course, but there's also the Smith versus Houck that we think is dispositive. And that is in case involving, it was a car wreck, but the facts are similar or applicable in this case is that a man was involved in a car wreck. And it was not until the discovery deposition that the plaintiff was able to find out that this man was on his way to a hospital to perform an operation or to perform services. And they were allowed to amend because they had no reason to know. And so I think it's a reasonable standard. Mr. Watson harps on the fact that you've got 1 year from the date that you know there was an injury. Well, there's no doubt that we knew there was an injury in August of 2018. The problem is we did not have reason to know the source of that injury really until September 19th, 2020, when that letter was provided. And again, those letters, like the one from Ms. Copeland suggesting that there were other defendants, I'm not aware of the law being very developed on that, on what that triggers. And that's at the time, even in 2019, we looked up the case law. We couldn't find it that said, oh, you must either find it right now or you don't have to find it, because there's no certificate of good faith along with those letters. It's just, we get these letters all the time now where they will list 10 different people that could be possible defendants. And that doesn't mean we need to sue all 10 of them. We have to then do our due diligence. The case that Mr. Walk, yes, sir.
Under that statute, that fairly recent statute, didn't St. Francis had a legal obligation to tell you if they knew of someone, didn't they?
Yes.
And they had an obligation to tell you who the proper party was, didn't they?
Correct. Yes, sir. And that's what we're hung up on is we couldn't get the correct property, and no fault of Ms. Copeland, even as late as the hearing on the motion to dismiss, she still didn't know who the correct defendant was. She still had not received a copy of the contract, and whether that's her client's fault or Mr. Watson's, but that shows you how difficult that is to then put the onus on us when St. Francis doesn't even know who the entity is. And so it seems pretty clear. And in the Bourne case that he refers to, I would only distinguish that is that he was made aware that there were pharmacies involved and they were on the prescriptions, and he could have looked at that. We had no documentary notice or any way whatsoever to really discern that Sodexo Operations LLP was the person. And then the other, just kind of as the catch-all, the back end argument, which is, I don't say it's a novel argument, but it's one I've not seen. In January of 2021, in January of 2020, I'm sorry, St. Francis filed an answer. And it was then that they filed comparative fault allegations against Sodexo Operations as a result of us, filing the notice of intent to sue letters. It was then that I believe we still had 90 days from then to properly sue Sodexo Operations Inc. It didn't make sense to non-suit them and re-sue them. We had already added them to the suit. We'd already made a claim against them. So the point being is there is no law on that. I'll be honest with you. I've not seen that litigated, but it just makes logical sense. If we had 90 days after January to add Sodexo operations, we added them long before that. So I don't see any reason why that wouldn't be appropriate. So I think the discovery rule clearly gives us time based on the facts. And these are distinctive facts and they're not argued facts. And so based on that, the discovery rule gives it to us. But even if for some reason you don't find the discovery rules in effect, the 90-day window given to us by the comparative fault allegations of St. Francis give us that extra 90 days well into the year 2020. So with that, if the court has any questions or has any other concerns or anything for me, I'm glad to answer them. But I believe it's as simple as that kind of case.
Let me ask you, Mr. Walk, after St. Francis answered and then raised the issue of comparative fault against Sodexo operation, what, if anything, did you do?
We didn't do anything. And the reason is Sodexo operations was already a party. So we had made Sodexo operations a party prior to them filing an answer. So the logic is, here's what happened. We were stuck on the horns of a dilemma in September of 2019. We had Sodexo Inc. well within the statute. We had St. Francis well within the statute. So before we were able to file suit, Sodexo Inc. sent us a letter notifying us that Sodexo operations, this was on September 19th, 25 days after the injury occurred. And I mean, 1 year and 25 days, I should say, after the injury occurred. So that's when we're on that dilemma of, okay, do we amend our notice letters right then, or do we have to hold on and wait? Do we sleep on our rights? If we don't act now and amend our notice letters based on this letter, are we sleeping on our rights? And so we made the decision to the day after amend our notice and add Sodexo Operations LLP on September 20th, 2019. We then waited our 60-day notice for Sodexo Operations LLP, and the other ones were far within that notice. And so it was not until I believe it was November, we filed our suit on December 5th, 2019. So at that point, St. Francis, Sodexo Inc., and Sodexo Operations were all three defendants in this case. So it was not until January when Ms. Copeland, on behalf of St. Francis, filed her defense or her answer and responded comparative fault and alleged comparative fault against, at this point, a co-party, Sodexo Operations LLP. And the point being, it didn't make sense to add someone that was already in the case. But what I'm saying from a defense standpoint is, worst case scenario, we would have still had 90 days if we had not added them. We just chose to act immediately, not to sleep on our rights. We didn't know the effect of those letters, so we wanted to make sure that upon receiving a letter saying Sodexo Operations, that we acted immediately.
And did you ever uncover the relationship between Sodexo and Sodexo Operation? What is that relationship, Mr. Wall? Do you know? We
have not. So here's what we know, because we've not been able to go into discovery. We had a motion to dismiss, and that's where we are. But here's what we know. We know it's the same counsel. We know it's the same agent for a service of process, the same address. So all of those entities are all on fours. There's no real distinction other than the corporate name as far as we've been able to discern right now. And so again, it's an unfairness if I'm not suggesting they're playing the shell game or anything like that, but were St. Francis not to be able to know the proper entity and they have the contract with them, it puts an unfair onus on the plaintiff to try to discern something that the person with the contract can't even discern. We didn't have access to those documents. We didn't have access to the contracts. And so we were unable, the only way we could do is through a lengthy internet search to find Sodexo Inc.
And have you ever had an opportunity to look at that contract between Sodexo Operations and St. Francis?
No, sir. We've not gotten to that point in discovery. That's the point. We had a motion to dismiss, okay. and that's where we ended up. And I mean, if there are no other questions, I have nothing further to add to the court. I appreciate your time.
Thank you, Mr. Walk. Mr. Watson, you have your rebuttal time.
Yes, thank you. And I'll just begin with talking about the allegation that there was no way to find out about Sodexo operations. It's our position that when the injury occurred and the plaintiff was aware the injury occurred as a result of the act of another person, that triggered the clock for the statute of limitations. The General Assembly provided the plaintiffs effectively a discovery tool within the act that allows them to issue pre-suit notices. And then, as your honors have pointed out, places a duty on the defendant receiving the notice to identify any other parties. While obviously the hospital only identified Sodexo, within, I think it was 2.5 or 3 months, Sodexo operations had been identified. So that 10-month gap between the incident occurring and the injury occurring and when that first notice was issued is very important to this case.
Well, Mr. Watson, let me ask you a question. I'm sorry, go ahead, Judge.
No, go right ahead, Judge Gold.
I was just going to say, from Mr. Walk says that they did a search through the Secretary of State's office, that St. Francis didn't even know who they had the contract with, and they couldn't identify who they had the contract. What else could they have done to identify Sodexo operations versus Sodexo Inc.? I'm not. Can you help us with that?
Sure. Well, I think the most important thing they could have done was timely issue the pre-suit notices when they were aware that an alleged injury had occurred, and obviously they believed the hospital was at fault for that injury. And obviously that pre-suit notice began the chain of events that pretty quickly identified Sodexo operations.
All right.
Mr. Watson, when you have a healthcare liability case and you know it occurred at a particular place, you don't immediately the next day obviously file a lawsuit. There are pre-suit notices required. There are also good faith affidavits required, and sometimes it takes a while to get those. So a delay of 6 or 8 months or 10 months before you actually send your pre-suit notice is not unreasonable. But let me ask you this. What is the relationship between Sodexo Inc. and Sodexo Operation?
Your Honor, they are related entities, but they're separate, obviously, legal entities. And the appellate court in Nashville actually addressed that issue in Shockley versus Mental Health Co-op. In that case, they were two similar entities, had the same service of process, had the same address. And the court said that notice to one was not notice on the other, that under the Healthcare Liability Act, strict compliance was required. So, that's my position as far as whether notice issued to Sodexo Inc. would qualify as notice to Sodexo Operations LLC. But I do not have the contract in front of me. Obviously, they are related entities.
Okay. And do they engage in the same business operation?
Well, Sodexo Operations was the entity in charge of the dietary services at St. Francis. Sodexo Inc.
Sodexo Inc. Does it provide dietary services to hospitals?
Well, I think that is part of their business.
That is part of their business. Okay. They both do the same thing, same office, same registered agent for service of process. Is that right?
The pre-suit notices were sent, I believe, to the same registered agent. That's correct.
Okay.
Well, I'll just quickly address the Smith case. Obviously, that was not a healthcare liability case. It involved a car wreck. So the notice issues obviously were not at issue in that case. There was no, the discovery rule from the Healthcare Liability Act did not apply to that case. So the court was reviewing that case under the general common law discovery rule. Have
you seen that contract between Sodexo Operation and St. Francis for food services?
Yes, sir. I believe we have received that, and we did do some written discovery, I guess, between the time that the motion to dismiss was denied and
Right.
when this appeal was filed.
And that contract that was signed between St. Francis and and Sodexo Operation, who signed that contract on behalf of Sodexo Operation?
Well, Your Honor, again, I do not have that contract in front of me, so I don't want to speculate, but it would have been some type of legal representative or officer of Sodexo Operations. But again, that's without looking at the document.
And would that officer also possibly also be an officer of Sodexo Inc.?
I do not know the answer to that question.
Okay.
All right. Counsel, thank you for your argument on this case. We will endeavor to get you a written opinion as soon as possible. Thank you.
Thank you.
This honorable
Tiffany,
court is now in
please
recess
adjourn.
until 1 p.m.
Thank you. Y'all are free to leave.